If you're one of the millions of business owners in the United States, at least for now, you're off the hook. Off the hook for what, you might ask? Remember that beneficial ownership information, or BOI, requirement that you were legally obligated to file before January 1st, 2025? Yeah. Late tonight, a federal judge in Texas issued a nationwide preliminary injunction saying, no, at least for right now, you don't have to file it. Judge Amos Mazant issued this 79-page ruling tonight, writing, Congress's commerce power cannot reach this far. If the court were to sanction such an extension of legislative power today, then there is no telling how Congress would control companies tomorrow. Now, the Justice Department has not yet issued a response to tonight's ruling, nor has FinCEN officially canceled the January 1st reporting deadline for business owners. But obviously, they are going to comply with this judge's order, and I will let you know when they make the formal announcement. So let me just back up here in case you're confused about what I'm talking about. You may remember I did a series of videos at the beginning of this year about this new BOI reporting requirement from the Financial Crimes Enforcement Network, or FinCEN. This requirement is a result of a law passed by both Democrats and Republicans in 2021 called the Corporate Transparency Act. That law created this beneficial ownership information requirement to help the U.S. government track down people who were trying to hide or benefit from shell companies or other opaque business ownership structures. The regulation was meant to catch criminal organizations using their businesses to launder money, finance terrorism operations, and other crimes. But it also required almost every single type of business, LLC, C Corp, S Corp, and so much more, to enter all kinds of identifying information to the federal government so they can know exactly who directly or indirectly owns or controls a company. As you can imagine, lots of business owners sued. And back in March, a federal judge in Alabama issued a narrow preliminary injunction saying only that specific group of plaintiffs who filed that particular lawsuit were exempt from filing a BOI while their case played out. P.S. That case is still playing out in an appeals court. But tonight, this Texas federal judge said, nope. No business owner in the United States has to file this BOI information, at least not as the case is playing out. Now, it's important to know the judge did not rule that the Corporate Transparency Act or the BOI requirement itself are unconstitutional tonight. He just ruled that the plaintiffs at this point had demonstrated a substantial likelihood that once all the evidence was presented in court, they would prevail. And he said if he allowed this January 1st deadline to stand, business owners nationwide would have their constitutional rights violated, and that would cause irreparable harm. The Department of Justice argued Congress passed this law and wants this regulation in place to help catch people who are committing crimes and hiding it through these fake companies. But Judge Mazant said that's not enough of a reason. He said while the Constitution does give Congress the power to regulate commerce and does restrict states from interfering with that power, the Commerce Clause does not justify regulating all companies based on nothing more than a fear that a reported company might shelter a financial criminal. No matter how laudable its goals, Congress's actions must abide by our Constitution. Now, it's very likely the Department of Justice will appeal this ruling just like they appealed the Alabama ruling. The question is, what is going to happen to both of these appeals once the Trump administration takes over in January? How will Trump's AG approach these cases and this BOI requirement as Congress laid it out? We will just have to wait and see.